Hi, welcome, Christel and Bart. We are kicking off a series of interviews from INSOL Europe of IPs. So you are both IPs, Christel in Luxembourg, IP and advisor, and Bart as well, IP and advisor in Belgium. So welcome to both of you. We are here to talk about a few words on the situation in each country and how IPs face this situation, this COVID situation right now. So we are close to the lift of the containment. So in each country is going to be a sort of new word. How do you see reforms and situation in your country right now? Maybe we could start with Christel, ladies first.
Yes, hello to both of you. It's very nice, to see you indeed. Well, in Luxembourg, we have an approach which is for temporary measures at least, which is a little bit different than what I understand is the case in other countries. So far, it's only the deadline for filing for insolvency for directors, which is suspended. This deadline is usually of 1 month. And for now, the directors are not under the obligation to file for insolvency if the company is facing financial difficulties. And of course, this measures goes with all economic measures taken by the government. We had aid scheme, loan guarantees granted by the state and work scheme. And it happens that some members of parliament have introduced a proposed law because so far creditors can still file for insolvency. And so this law proposal intends to forbid creditors to file for insolvency. So the members of parliament who have introduced this law proposal think that this situation, there is a kind of distortion and that, of course, companies should be ensured that they will not be forced into insolvency by a creditor. The point is that as it's only a proposed law and not a bill of law, there are probably few chances that it will be voted. But in practice, what's interesting is that commercial courts, of course, are still hearing insolvency matters, not through a video conference, but they are still hearing matters, but at least only urgent matters, which means that if a creditor wants to file for insolvency, it will have to prove that its insolvency filing is an urgent matter. And it happens in practice that only less than 10 cases have been through this process, and the courts have only issued less than 10 new insolvency judgments so far. So it's quite working already in practice, even if we have not a law forbidding creditors to file for insolvency. I don't know, Bart, how is it in Belgium? I understand it's a little bit the opposite position that you have taken.
I don't know. Well, we have so many companies in distress, and that's the same in all countries. The Belgian government has taken measures to calm down the situation and diminish the pressure on our enterprises. And so several measures have been taken. And what is very important to stress is that all these measures are automatically applicable to all enterprises. So enterprises that wish to benefit from the measures taken by the government do not have to prove first that they are in difficulty. They are presumed to be in difficulty. And should the creditor not be in line with the measures taken, and should the creditor, we'll discuss it in a few minutes, it's diminishing the possibility to open proceedings. If the creditor is not fine with these measures, it's up to the creditor to address the court, president of the court, and to ask to lift these measures and to be able to, for instance, to enforce judgment against debtors. So it's very important that it's a quite drastic measure that concerns all enterprises. And what are then exactly in the most important measures? First of all, there is a protection for all enterprises against the opening of insolvency proceedings, of bankruptcy proceedings. And that if the initiative thereto is taken by the creditor. So the company itself in distress can still file for bankruptcy itself and have that relief, but it cannot be opened on the initiative of the creditor. Same counts for judicial dissolution and reorganization proceedings. We have some proceedings that are also possibly opened on the initiative of a creditor, and these initiatives also are suspended. We also have protection against enforcement of debt by a creditor. Creditors can, for the time being, not levy attachments or cannot enforce attachments against their debtors. And our enterprises that normally, and that's same for Luxembourg, if I understood you well, are obliged to file for cessation of payments at the court, and should do that within 1 month after the cessation of payments. This delay is also suspended. So they are not obliged to file for and to provoke the bankruptcy. They can still try to avoid it. And then there is one measure that is quite controversial, and that is that no creditor can, or no contractor can rescind or terminate contracts for the time being, not unilaterally and not judicially. And this is also a quite drastic measure, but you should take into account that it's temporary measures and that they will end for the time being on the 17th of May, but by simple decision of our government, the measures can be extended in the time. So I don't know if there is now such a difference with Luxembourg, Christel.
Well, we have not taken, this kind of measures regarding agreements. So you can still, maybe, terminate an agreement. I don't know, Jean. How is it in France? Do you have this kind of measures for contracts, or what are the measures in France, indeed?
In France, you have a huge set of measures as well, like in your country. First of all, economic measures, of course, guarantees of loan. The envelope is quite amazing because it's close to 400 billions of loan guarantees by the state. So this is finally the oxygen given to companies in distress or not in distress. It's of course more difficult for companies in distress to access this credit, but everything is done to give access to the most part of companies. So this is the first thing. On a legal point of view, reforms have been quite fast because the government has initiated a series of ordinances giving globally a breathing space to the debtor. Like in Belgium, you cannot be pushed to insolvency by a creditor during this period and an extended period. So it means you give a breathing space to the debtor, and we allow the debtor, legislation allows the debtor to go to safeguard or to redressement judiciaire, or of course to preventive restructuring more easily, giving here more time to deal with its difficulty in order to go through this period. So government has acted quite fast, and the court have reacted quite fast as well, because we are now experiencing many virtual hearings, so it's growing. We have a sort of new protocol on the hearings, and it allows us to go faster when it's necessary on urgent cases. So you can open a proceeding if necessary, and then you can exit. The idea is as well to be able to exit faster from a proceeding. So this set of measures are quite incredible, but they are of course adapted to the incredible situation we are living in France, like in your countries as well. Can you say a few words about how you see the future reforms in insolvency fields, and how can we deal, for instance, right now when we face difficulties in a group of companies in your respective countries? Is there a solution for double Luxco in Luxembourg, Christel? Or is there in Belgium any specific reforms on the reorganization process? Bart, I understood that in your country you can imagine a transfer of assets to the initial debtor Could you say a word about that in your respective countries, Christel and Bart?
Who will start? Christel, you start?
Yeah, if you want. I mean, it's a very good question. Indeed, I mean, well, as you probably know, we don't have real reorganization or restructuring proceedings so far. And well, usually, I mean, if there is a group of companies with a holding in Luxembourg, we will try to find other solutions in other jurisdictions, with just having the commis of this company in one of these other jurisdictions. We used to work a lot with the UK proceedings. We'll see how it will go, I mean, with the Brexit. So it will be interesting because the Netherlands now have a scheme. So maybe, I mean, it will be good to try. But what is important as well is that we have a bill of law, which was introduced into Parliament in 2013, so quite a long time ago. It's based on the Belgium law, but it's now in its last stage for approval, and we hope sincerely that it will be voted soon. Indeed, I mean, the bill of law, as it has been amended several times, is now almost compliant with the directive, and it will be very interesting to have this law. Indeed, I even think it will be really of the utmost importance that this law will be voted, because, of course, as in a lot of countries, we are thinking that there will be a lot of cases after the crisis, not soon, but at least, I mean, before the end of the year. And it will be good to have another proceeding, and not only, I mean, just not only, I mean, the idea of bankruptcy, and it will be good that companies have other solutions. And we will see, because in this bill of law, we have a conciliation proceedings for reorganization. We hope that we will be able, I mean, to use maybe, I mean, the French experience on that, to make things work for local companies, but also, of course, for a group of companies with holdings in Luxembourg. I understand, Bart, that in Belgium you're not using conciliation but mediation. Maybe, I mean, it's something, I mean, which
Yes.
could be interesting.
Yeah. Yes, yeah. There are a few things when I hear you talking that I would like to say. And so already the current Belgian legislation provides, quite exceptionally in Europe, for mediation in the framework of companies of distress. And mediation in Belgium, we call it a médiateur d'entreprise. So it's in English, company mediator. The company mediator can do both things. He can solve conflicts, as a normal, ordinary mediator can do, but he can also have the task, and that's a very broad task, of contributing to the plan of the company in distress to reach a turnaround of its situation. So the mediator can at the same time be a tool of dispute resolution, and can at the same time help to draft a plan within a formal reorganization structure and proceedings, or even in a completely out of court situation. And then there were two other aspects, and these mediation, I think, can be very useful in the current crisis, because there is a lot of goodwill, there is a lot of distress due to the crisis, but there is a lot of goodwill of the people. And so I think that people are willing to find solutions now, and are willing to have our companies survive. And so I think the mediator can be a very helpful tool, and we should not underestimate it. On the other aspects that Jean was touching on, and I identify two aspects in his question, and that was first, what is going on in the reform of our legislation. So currently our government is doing some preparatory work for the implementation of the directive. Time is going on, and we have to work on that implementation of the directive. But as you know, in Belgium, for the time being, we have only a provisional government with specific powers to fight the crisis. But it's not a government with full power, and we are so very much waiting for a final federal government being put in place. And so preparatory work is being done for allowing the government then to adopt new legislation that will correspond to the requirements of the directive on preventive restructuring frameworks. We have a concern with the Belgian state has a concern with the decision of the European Court of Justice that puts a lot of question marks on our formal reorganization proceedings with the transfer of undertakings. That will also hopefully be implemented. A solution for that will implemented in the new law to be adopted. And then there was the other question, which is very interesting, that was raised by Jean concerning shareholders or directors of a company in distress taking over the business. And indeed, contrary to, if my understanding is right, your countries, this is possible in Belgium. The shareholder or former shareholder of a company in distress, or a director or a group of directors and shareholders of a company in reorganization proceedings can make an offer to take over the undertakings. And I know there is a lot of controversy about it and there is a lot of abuse that is possible, but we think that in some cases it's the best solution, and sometimes there is only one candidate to take over the company, and then it should be allowed. And there are some safeguards that are put in place in the law, essentially that as a candidate to take over the undertakings, being a shareholder or a director, you cannot abuse this situation in the sense that you cannot use privileges that you have and that another candidate does not have, and in this way attract the decision of the court in your favor. I was thinking, for instance, of intellectual property. If you have intellectual property that is essential for the business, and you have put that in another company, which is often the case, you cannot take over the business knowing that you have access to that intellectual property and that other candidates do not have that access. So you should then grant that access also to the other candidates. And if everyone is equal in front of the judicial administrator, the monetary justice that is realizing the transfer, then the former shareholder can easily compete with the other candidates or can only be the only candidate. So it's, I don't know, it's not a black and white situation, and there is a lot in favor of the French and Luxembourgish legislation, but there is also a lot to say that you should maximize the chances for the continuation of the business and saving as much employment as possible. So that's why we have maybe another view or another application in Belgium. I don't know, Jean, if my answer is satisfactory to your question, or?
Yes, very clear. Many thanks, Bart, for this summary of Belgium situation. Just to say a few words on France, on what you just raised on the conciliation. Of course, we've been doing that for now more than 20 years in France, so we are quite well prepared to this directive in this way, where we'll have some adjustments to do. It's on the crown down process, and of course in the build of the committees of creditors, which is not exactly the same in France like in the directive, but we have this experience on the preventive restructuring, and it's always on big groups. It's always the best way to enter a discussion with main creditors and to imagine what is the best scenario and what is the best, sometimes collective official solution or sometimes amicable solution. So I'm very happy to see that it grows in Europe, because I believe, like you, Bart, it's very, very important to, in the COVID times, to difficulties. Thank you all for all this contribution. I propose you to say a word as a conclusion, Christel and Bart, on this COVID situation.
Well, indeed, I mean, it's a pity that we won't be able, I mean, to see each other in Sorrento for the INSOL Europe Annual Conference this year. But definitely, I mean, it's a very good thing that we have all this technology. I mean, that helps us to have this kind of conversation. And I'm really glad, I mean, that we'll be able to have this conversation.
Yeah, we all live in stress situations. No one is happy with what is happening. We are all very much looking forward to the end of all these measures that unfortunately are necessary. And we should be grateful to all the people that help everyone in these situations. And what the positive side is that we see a lot of goodwill, and we have addressed that already in the talk. We should be very flexible in the application of all the solutions we have to help everyone. And we are looking forward to seeing each other in normal circumstances again. And maybe the final word from you, Jean. And
I can say better. Thank you, Christel. Thank you, Bart, for this conclusion, and keep in touch for next reform and next situation in our country, next episode.